Section 482 of CRPC in the context of the Supreme Court judgments is what the discussion topic today. A court's inherent powers are outlined in Section 482 under the 37th chapter of the code titled Miscellaneous in CRPC. Section 482 of the CRPC reads as follows: High Court's inherent powers shall not be limited or affected by this code in any way that would limit or affect the inherent power of the High Court to make such orders as may be necessary to give effect to any order made under this code, to prevent abuse of any court process or otherwise secure the ends of justice. This is what the essence of Section 482 of the CRPC. Now, let's look at the purpose of Section 482 of the CRPC. Under Section 482 of the Code of Criminal Procedure, the High Court has both administrative and judicial powers. As a result of the Code of Criminal Procedure Act of 1923, the High Courts were unable to render, of course, complete justice even when the illegal conduct was palpable and obvious. According to the Honorable Supreme Court in State of Karnataka versus Muniswamy, AIR 1977 SC 1489, the section provides for three instances where the inherent jurisdiction may be exercised: to implement an order under CRPC, to prevent abuse of the court's process, and to ensure that the justice is served. These are the three occasions warranting the exercise of Section 482 of CRPC. Moreover, the Allahabad High Court stated that the section serves as a reminder to the High Courts that they are not only courts of law but also courts of justice with respect to courts subordinate to it. The inherent power of the High Court is inalienable as long as they are exercisable with respect to a judicial order and secure the ends of justice. They are necessarily be judicial in nature. If a party has not approached the High Court with clean hands, the court may refuse to exercise its discretion under Section 482. Now, let's look at how does High Court exercise its powers under Section 482 of CRPC. Under Section 482 of CRPC, inherent powers given to the High Court are relating to the authority of the High Court to quash an FIR, investigation, or criminal proceedings pending before it. Based on the facts of a case, this power may be exercised in order to secure justice, prevent abuse of the court process, and make such orders as may be necessary to give effect to any order under this code. Any miscarriage of justice can be prevented by exercising the court's powers under Section 482 of the code. Other provisions of the code do not limit or curtail these powers. Nevertheless, such inherent powers should be exercised sparingly and with caution. Section 482 provides inherent powers to the court only when no other remedy is available to the litigant. Let's note this point again. Section 482 provides inherent powers to the court only when no other remedy is available to the litigant and not when a specific remedy is provided by statute. A High Court will not exercise its powers under this section if there is an effective alternative remedy available, especially if the applicant has not taken the advantage of it. Now, let us evaluate the interpretations relating to Section 482. Interlocutory proceedings in a subordinate court are not ordinarily interfered with by the High Court, but it's obliged to intervene if any Indian citizen is harassed by illegal prosecution. A special or an extraordinary reason could also lead it to do so. According to the Supreme Court, nothing in the code, not even Section 397, can affect the scope of the inherent powers protected by Section 482. It is necessary for High Court to intervene in situations where the impugned interlocutory order clearly causes an abuse of court's process in order to secure the ends of justice. And Section 397(2) cannot limit or affect the exercise of the High Court's inherent power. Furthermore, the Supreme Court has held in Madhu Limaye versus Maharashtra that the High Court's inherent jurisdiction is governed by the following principles. 1. In cases where there are specific provisions in the code for redress of grievances or aggrieved parties, power should not be used. 2. To prevent abuse of any court's process in order to secure justice, it should be exercised sparingly. 3. The law should not be exercised against any other provision of the code that expressly bars it. In several Supreme Court decisions, it has been attempted to lay down more precisely when the High Court can and cannot exercise its powers under Section 482. State of Haryana versus Bhajanlal, 1992, Supplementary 1, SCC 335. A two-judge bench of the Supreme Court of India examined the provision of Section 482 and the power of High Court to quash criminal proceedings. Following are the guidelines that High Courts must follow as they exercise their inherent power to quash criminal complaints in accordance with the Supreme Court's ruling. First and foremost, in cases where the allegation included in the first information report or complaint does not prima facie constitute any offense or make out a case against the defendant. Number two, if the allegations in the first information report and any other materials accompanying the FIR do not disclose a cognizable offense, a police investigation under Section 156(1) of the Code is not justified except by any order of a magistrate within Section 155(2). If the allegations made in FIR or complaint and the evidence collected in support of the same do not reveal the commission of any offense against the accused, as contemplated by Section 155(2) of the Code, a police officer cannot investigate an FIR containing allegations of a non-cognizable offense without an order from the magistrate. An FIR or complaint which contains absurd and inherently improbable allegations for which no prudent person can reach a just conclusion that there is sufficient ground for the accused to be prosecuted. Number 6. The institution and continuation of criminal proceeding is barred by an express legal bar engrafted in any provision of the code or the relevant act under which criminal proceedings is instituted, and or where there is a specific provision in the code or the concerned act that provides efficacious redress to the aggrieved party. An allegation of malafide in a criminal proceeding and or where the charge is maliciously brought with the intention of retaliating against the accused due to private and personal grievances. Now let's look at the limitation of Section 482 under CRPC. Despite the wide scope of the inherent jurisdiction of the High Court under Section 482, it must be exercised sparingly, carefully, with caution, and only when justified by the specific requirements of the section. To do real and substantial justice, which is the only purpose of courts, they are to be exercised ex debito gestutiae. In many of its judgments, including Monica Kumar versus State of Uttar Pradesh, the Supreme Court has taken this view. A proceeding under Section 482 does not require the High Court to make any findings of facts, particularly when two courts below have reached concurrent findings. A question was posed by the Honorable Supreme Court in State of Bihar versus KJD Singh as to whether criminal proceedings could be quashed even before trial began. In its decision, the Supreme Court ruled the inherent power under Section 482 must be exercised to achieve justice and not arbitrarily to shorten the process of criminal trial. The Supreme Court deprecated the practice of staying criminal trials and police investigations excepting in exceptional cases. In R.P. Kapoor versus State of Punjab, the Honorable Supreme Court limited the powers of the Honorable High Court. In the Supreme Court, it was held that inherent powers of High Court cannot be invoked in matters that are directly covered by the specific provisions of the CRPC. The inherent powers under Section 482 may only be exercised when no other remedy is available to the litigant and not when a specific remedy is provided under CRPC. So the precedent of the Supreme Court prohibits the High Court from exercising its powers if a more effective alternative remedy is available, especially if the applicant has not taken advantage of it. Now, having considered various precedents of the Supreme Court with reference to Section 482, let's have a brief conclusion. There is a wide scope of Section 482 of CRPC, and it is essential part of the law to meet the ends of justice where injustice can occur. But at the same time, the power is too wide and the courts need to use it wisely and according to the prudential guidelines laid down by the high courts and supreme courts from time to time. With changing times, needs of the hour, and guidelines framed by the Supreme Court in several of its judgments, Section 482 has undergone a number of changes in its current form. Courts feel compelled to do so since the said section, which gives wide powers to High Court, has been heavily abused by the litigants and their lawyers to enable the High Courts to provide proper justice and simultaneously curb the filing of fictitious complaints to avenge personal grudges or to delay the trials. Section 482 of the CRPC has to be used very sparingly. Thank you very much for your patient hearing. Hope the information is useful to you all.